Right, I think we'll make a start. Hello, everybody, and welcome to the latest of our Life Sciences Live webinar series. I'm Carol LePage, and I'm Head of Life Sciences Tax here at BDO, and we'll be chairing the discussion today. We've got a great panel of speakers lined up, as you can see on the slide there, and we're going to be talking about all things IP. So over the next hour, you're going to hear from Ross Robertson, who is an international partner here at BDO and international tax partner here at BDO, and also a deep specialist in IP. Samantha George, who is a director in our business services and outsourcing team, and she regularly advises businesses on how to account for things in their financial statements. Sam Schofield, who is from Aon, and he is an associate director there in their structured solutions business, focusing on working with lending partners and helping to facilitate structured financing. And last but not least, Rebecca Ding from Aon, who is an associate there in their IP risk team, where she focuses on IP liability insurance for innovative and IP-rich companies. So a couple of quick admin points before we go on to the agenda. This is being recorded, and the slides and the recording will be shared with you afterwards. And secondly, please ask questions as you go, putting them into the Q&A. We'll either pick them up at the right time during the discussion, or we'll do our best to come back to them at the end, and there will be 10-15 minutes hopefully at the end for your questions as well, if you want to save them up for then. So just a quick look at the agenda. We're going to be talking about, as I said, all things IP today. So we're going to start with Ross covering intangible asset strategy, framing the IP life cycle as well. Samantha will pick up accounting considerations, and then we're going to have a discussion where Sam and Rebecca will cover some of the interesting things they're seeing in their space as well, and we'll just talk through the IP life cycle. So from there, I'm going to hand over to Ross.
Thanks, Carol. Welcome, everybody. Great to have you with us here today. So I suppose we're here to talk about everything intangibles, and probably makes sense just to level set around that before we get into it. And when we think about intangible asset strategy, we really think about it through three broad lenses. So first, there's a legal and risk lens. In other words, required actions to legally protect developed intangibles and to manage associated risks. And as businesses seek to disrupt and are in turn being disrupted, new intangibles can be created at pace, and it's really important to ensure that the right consideration is given to legal and risk matters as that development occurs. And that's coupled with new regulation in respect of some of the new areas of development, such as around AI and related data privacy matters, which really need an active review. Then from a tax perspective, I guess the key point in the tax world is that profits attached to value drivers and intangible assets are often a key driver of value within many businesses in the sector. So given their comparative mobility and the potential for geographical spread of functions connected to the various intangibles functions, they have been a key focus of changes to tax policy and indeed tax controversy. But they're also a key battleground for territories that are seeking inward investment through reliefs and incentives that are applicable to high value assets. And there's a constant change in what those reliefs and incentives look like, with recent changes to the UK R&D regime being just one example of that. And then finally, certainly not least, there's also the commercial lens. Investment in intangibles is always a focus area for businesses, and therefore ensuring that risks are managed appropriately and opportunities are maximized is the key to delivering the optimal return on investment on any spend on intangibles. So I guess in summary, what we're trying to sort of convey through this presentation is that if you have not revisited your intangible asset strategy recently, it is likely that something will have shifted from a legal, tax, or commercial perspective that needs to be considered and baked back in. Otherwise, your strategy will rapidly become detached from the reality of the business or the wider world. Next slide, please. So in applying those lenses, we find it's often useful to reflect on the intangible assets life cycle from development through exploitation and potentially exit. Having clarity on the intended outcome from any development activity and setting up the right structures, frameworks, and governance at the outset is often key, as it can be very costly to change structure or approach once IP has been developed and a structure has been established around it. If we start at the start looking at development, we really think about funding sources and strategies, establishing the right legal holding structure from day one, as well as wider legal matters relating to the protection of IP. We think about the R&D model and how we optimize that at global scale. And we think about what grants or similar incentives may be available to increase our overall return on investment. And then as we move through to exploitation, we really need clarity on what the assets of the business actually are. Registered assets are easy to identify, and it's often the unregistered assets where the focus is required. And we look at what we call the value chain analysis, so analyzing the key drivers and contributors of value in a business and ascribing those value drivers to functions, people, and in turn entities. And then we look at the operating model design, so determining the most effective way to take a product or service to market at international scale. So that intersection of the corporate strategy and the business model, and how do we really get that humming in the right way. We think about what governance is needed to deliver on the intended benefits of a structure or to mitigate any associated risks. And that's all considered as part of a holistic tax strategy that cannot fundamentally be detached from the legal or commercial and operational reality of the business. And so the key thing to all of those components is that the inner part of the wheel need to be considered together. So addressing any of those single areas in a silo is likely to result in a suboptimal outcome. So we sometimes see businesses trying to set their IP strategy through a tax lens only, or through a legal lens, or just thinking about it from the perspective of what is most natural for the business. And the right answer needs to be all the stakeholders from those different functions coming together around the same table to get that truly holistic view. And then unfortunately, once you've been through that cycle, there's constantly external events that will disrupt that strategy. And so it needs to be regularly revisited. And we always talk about an IP strategy as being a live strategy. You need to set a strategy, but then constantly monitor it and evolve it in response to the external forces that are impacting on the business, be that regulatory change, legal change, or indeed changes in the business itself and its strategy for what products it wants to develop and how it's going to take those to market. So it's a very dynamic process of setting and managing an IP strategy. Next slide, please. So there's a number of stakeholders involved, and there's external events that will impact on whatever you choose to do. So where do you start? And there's undoubtedly not one size fits all, but the way we approach it is through a sequence of activities to provide some structure and set the key parameters for defining the strategy as early as we possibly can, but also to try and recognize the inevitable fluidity that exists in any business. So first, I'd say the most critical thing is really a comprehensive review of what intangibles the business actually has. And that's in particular stretching into the unregistered asset category. And it's going beyond what we might think of as intangibles in an accounting sense of the word, which Samantha's going to come on to talk about as well. And in practice, we find very few businesses are actually able to clearly articulate their full inventory of intangible assets, but it really is a critical foundation stone in developing your IP strategy. Second, we then look at the value chain and we try to assess how those identified assets are used in the business and how they drive value. And that helps to reflect on the legal, risk, and tax aspects of the strategy design, and really focus in on which are the bits that we are truly important, that we need to give particular focus and attention to. Third, we then take a step back and say, okay, well, we've got a state of view of where the business is today, but where is the business going? And then we need to make sure that the strategy is fit for purpose for those future outcomes. So that will consider life cycle of components of the IP. Are they sort of close to end of life, for example? But also how the operations themselves may evolve, so that we're trying to build a strategy that is as future proof as it can be. And within that, inevitably, we would always favor a strategy and a structure wrapped around that that gives us flexibility for change, because change is often inevitable. So fourth, we then start to look at the reliefs and incentives that are available and how that overlaps with the assets and functions of the business, both current and planned, or what may be the art of the possible, where there is sort of design flexibility within the system. And in doing that, we're looking to achieve the overall optimal outcome of the operation of the business model as it aligns with the world of tax and related financial incentives. And then fifth, if the strategy results in a change to current arrangements, so maybe we're changing the ownership location of IP, or there's movement in functions or responsibilities across the group, we really need to think about what is the impact of that change from a legal, tax, accounting, and operational standpoint, and assess what costs, risks, opportunities there may be that are associated with that change, and how we best manage that. And then finally, it's really about monitoring and evolving that in response to developments within or outside of the business. So hopefully that gives a bit of a framing of at least how we think about IP through the life cycle. It is inevitably a fluid process, but there is a clear structure that you can put in place to manage that. And it's about getting the right people around the table, thinking about it as early as possible, and really setting that strategy with a view to not just what the business looks like today, but what it may look like in the future, and trying to incorporate that flexibility to deal with what may be known or potentially unknown, but somewhat inevitable change. So with that, I'll hand over to Samantha, who's going to give us a little bit more on the accounting considerations we see around IP and intangible assets.
Okay, thank you very much, Ross. That's great. So as Carol said, I'm a director in business services and outsourcing. I lead for domestic life sciences, and I'm focused on financial reporting as well as outsourcing. So just going to take you through some of the accounting matters that need to consider on this, because as Ross has said, it's all about identification. And then of course, once you've identified them, you need to record them. So how do we do that? Next slide, please. So what does come under intangible assets, and what does intangible assets actually exclude? Well, there's a number of varieties of intangible assets listed there. So we could have intangible assets that have effectively been bought by way of a business combination. We've got items that we're holding for sale under the ordinary course of business. Massive area around internally generated intangibles. And as well as that, you know, there may be an intangible asset that you've purchased that's separately identifiable. It's worth saying intangibles are a bit of a mystery to some, but it's not including goodwill, which is a completely separate category. So next slide, please. So when do we recognize an intangible asset? Well, generally, Financial Reporting Standard 102, which is the basic financial reporting standard for most UK companies, unless they've chosen to adopt international financial reporting standards. So it's called FRS 102 for short, basically says you should recognise an intangible asset if you are putting in, effectively developing something where it's probable that you will get future economic benefits flowing to the entity. So there's clearly a huge amount of thinking and a huge amount of judgment here. So it's not as straightforward as I bought a car, I bought a piece of equipment, what have you. There is some thinking about this. Additionally, it can be recognised only if you can measure its cost or its value. And some of that around, for example, R&D spend could be, you know, we've got R&D staff working on multiple projects. Big firms are going to have systems in place. For smaller firms, can you identify how much of that time is being spent on a particular project? You may have a number underway and your front runner doesn't suddenly work out, and you need to be focusing a lot more focus on one of the other projects. Have you made sure that you can measurably, reliably measure the cost or the value of that? Next slide, please. So we've got, I touched on separately acquired intangible assets. So they must meet the probability question. So sometimes you buy an intangible asset and you're very excited about it, but you look at it and you go, actually, this doesn't work. I can't commercially develop that. So you're going to be writing off that item, and you're not actually going to be putting it through to your balance sheet. As intangible assets required via a business combination, technically they should meet both of those requirements. It's arisen from legal or contractual rights, and it's a separable asset, so you can put it in a box and know what it is. But in fact, the standard gives you the ability to meet the probability question and one of those requirements as well. And a good example there would be licenses. I think it's worth saying as well, a lot of companies haven't really looked at the whole proper question of intangible assets. What is an intangible asset? A lot of companies are writing off their R&D spend to their profit and loss account. But the standard actually says, if this is something that you can get a commercial benefit from in the future and you can measure it, you should actually recognise it as an intangible asset. And so for those smaller companies that may be on the call, it's worth having a look at that in some depth. We can move to the next slide, please. So financial reporting standard, again, goes into quite a lot of depth about this. And it's section 18 of the financial reporting standard 102. And really what it says is when you're first researching something, so you don't know if it's going to work, you can't include that. It's not an intangible. It's a piece of research on which you cannot tell the outcome. So it's pretty obvious you're going to have to expense those items to the profit and loss account. The development phase, there is a very long list of conditions to be met to be able to then say, yes, we've got a clear asset here in development for R&D, and we are going to be able to actually capitalise that. We're going to probably cover some of those items more as we talk through the panel debate. But section 18.8 is your friend on this one. And then if you can't actually separate the R&D phases because it's just too merged, you can't actually tell which bit is which, then you don't get to include that as an intangible asset. So it's very much about assets in the development phase that are going to be able to go forward and be included on your balance sheet. So if we move on again, please, next slide. So what do we do in subsequent financials? Well, okay, we've been able to measure the asset, we've got it on the balance sheet. What have we got to think about? And it's very similar to things that you have to think about with fixed assets, tangible assets. So obviously you've got a useful life. What is the measurement of that? How is it going to actually give you revenue? How many years do you think you're going to get revenue out of that IP, that intangible asset? So you need to know that number. You'll then effectively write down its cost over the number of years in question, and those blocks will be the charge to the profit and loss account for each year in question. However, you're also required to have a think about intangibles, as Ross was saying, on a regular basis, and certainly for purposes of the accounts, have a think about, have I actually got any impairment to this intangible asset? So it could be that something's happened, you've got a great drug product, your competitors come along and launch something into exactly the same marketplace, and you've had to think about how much market share you're going to get. Is the value really as good as it was before, etc. Hopefully you're not impairing it to zero and you're still seeing some value, but there is a requirement to have a look at the accounts for impairment and a number of tests on impairment, and have we really got a loss in value of this asset, in which case you should write it down in the year in question. And of course it could go the other way. So you may write something down and then a while later market conditions have changed, something else has changed, you've got a reason to actually reverse that impairment back through the P&L again. And then finally, of course, when we get to exit, there'll be a disposal of that intangible asset within the profit and loss account, within the balance sheet, and any profit taken to the profit and loss account. One final piece of caution, one of the things you do need to look at, particularly for R&D spend that's been capitalised, is deferred tax, because you will be writing off the value of that asset over time in the accounts. So you have a percentage release through amortization each year. But if you've taken a particular election for tax purposes, then your tax code may actually be showing 100% of those costs in the profit and loss account, in which case you've got a timing difference between your accounts and your tax, and you are going to get deferred tax coming out as a result. It's a point often missed, and it's one to be quite crucial about, because a few million here, a few million there, pretty soon, as they say, you're talking real money. So you need to have a look at the deferred tax aspect as well, and make sure you're on top of that as part of the review of your accounts. And I think with that, that might be the end for me at the moment. And over to you, Carol.
Great, thanks for that, Samantha. Some really interesting context, I think, to frame the next part of the webinar, where we're just going to almost do a bit of a canter through the various phases. And Ross, I think I'm going to come to you first, if that's okay. Just thinking about the comments that you were making. You touched on how you need to look at things holistically. But if you put your tax hat on, I guess, for a minute, what sort of opportunities and risks should we be thinking about, say, if you're in early stage, just in that kind of development phase?
Yeah, very happy to put my tax hat on. It's my favorite hat.
Yeah.
So I think I would always start with, we need to be really clear at the start on where the IP is actually owned. And one of the reasons why I say that is I come across many businesses where, for reasons that are entirely understandable to me, a business is developing an intangible through contributions from different parties around the group, but there may be limited, if any, documentation in place to provide clarity on the relationships between those parties. And it's important not only from a transfer pricing perspective, but also from a fundamental legal perspective, because often legal reality will say, well, the IP is developed, is owned by the company that employs the people that have developed the IP, absent any agreements to the contrary. And where we come across situations where there's a lack of clarity of the ownership of the IP, it gets really complicated in terms of whether we're trying to build a tax strategy or on a future exit of trying to bundle and package that up in an appropriate way. And then I think once we've looked at the ownership of the IP, it inevitably turns to, well, what are the routes to increasing return on investment? Grants and incentives are a key part of sort of looking at, well, can I get some money to help me actually build this thing? And then the R&D reliefs come in terms of, well, once I've spent the money, can I potentially get some kickback in relation to that, which I can then reinvest in further development of the IP. And then once you're through the development, it's things like the patent box or innovation box regimes in terms of optimizing the return on exploitation. But I think the thing that ties all of those together is the structure really matters. So who owns the IP and how are different parties interacting with one another will have very different outcomes in terms of the end state. So we'll no doubt have some experts on the UK R&D regime on this call, and you'll all be familiar that you can have very similar looking economic arrangements, but subtle changes to the relationships between the parties means that the R&D rules apply in a different way and can deliver a better or worse outcome depending upon which side of the fence you're on. And likewise, we've got quirks within the R&D regime, like under the changes that are coming in, foreign R&D costs are no longer claimable, but there's a quirk that if those foreign costs are actually incurred in a foreign branch of the UK company, they are still claimable. So the structure makes a really big difference. And the reason why I also mentioned patent box and innovation boxes in the development phase is because the way in which those regimes are established, there's an inherent linkage between the ultimate exploitation of the IP and how the R&D was undertaken that leads into that exploitation. So you really need to think about the optimal position for exploitation of the IP if you're going to be relying on a patent box or an innovation box at the point that you're developing the IP, because that history will matter in terms of the ultimate outcome.
I think that's a really important thing. If people take nothing else away from today, I think that it's around thinking early and being really proactive about strategy, because if you don't think early, you can get tripped up later down the line, and it's harder to fix. Samantha, I'm going to move on to you, as you gave me a perfect in on the question there, just about the development costs and test for capitalization. Also, presumably, before you get there, when you are doing that pure research, you're just burning through cash, and your P&L is just going to be very clearly loss-making as well. So it'd be helpful almost to understand sort of when you move from research to development and what tests you need at a very high level in terms of that development piece.
Yeah, sure, Carol. Yeah. So the standard's pretty prescriptive here, and there are no less than 6 tests that have to be met. So it frequently cause some head scratching amongst those considering this for the first time. So one of them is the technical feasibility of actually completing the intangible assets, because it could be that you've done a lot of research, you can see the commercial market, you can measure the value of your intangible asset, but you realize it's going to take a huge amount more funding than you've actually got available to complete, for example, and there has to be a big rethink about how you're actually going to do this. One of the questions is, do you do it? Of course. So that has to be technically feasible for you to be able to complete the intangible assets so that it will be available for use or sale. So it has to be feasible. Secondly, you have to have the intention, i.e. you've made the decision to carry on. And then thirdly, you've got the ability to either use it to generate revenue or to actually sell it once it's completed. The other things you've got to think about is what is the market? Is there a market? What is it? How does it exist? Where is it? How do you define that? And have a look at sales forecasts into that market as well. And then you've got the necessary resources. It's slightly different to technical feasibility, but you've decided it's technically feasible. You've also got the resources, financial, technical, and other, to be able to complete the development. And then once you've done all that, the final test is you can reliably measure things all the way through the development stage so that you can actually put it on the balance sheet. But obviously, as you say, Carol, you're burning through research monies, just straightforward losses in the P&L. Why would you not show your value on the balance sheet as soon as you can in terms of actually capitalizing that intangible asset? But a word of warning, once you've decided to do that, all other expenditure on the similar projects are also required to be capitalized in the same way. And we do occasionally get clients who want to have a debate about what that means. So lots of things to think about there.
Thank you. Interesting. And I guess that there is that funding issue that you were alluding to, particularly in that development phase when you're pre-revenue. I'm going to bring Sam in here. And Sam, in terms of sort of IP, it clearly is a life sciences business's biggest asset in due course. So how can that be leveraged to help its cash flow?
Yeah, sure. It's a good question. I think potentially it's maybe worth taking a step back and sort of understanding the types of borrowing that sort of we're able to help, particularly in the life sciences space. Sort of broadly, we're pretty industry agnostic, and I think interestingly for this call, the one area, or I guess sort of sector we do sometimes have a few more restrictions within is the life sciences space. And that's primarily driven by the fact that a lot of the insurers that we work with, not a lot of the lending partners that we work with, have low appetite for binary risks. And clearly, with sort of many earlier stage sort of pharma or medtech businesses, there are sort of looming regulatory approvals that need to happen. So we can have issues working there, but certainly where sort of those approvals have been granted or there are no approvals upcoming, that's certainly where we can look to be helpful. From a sort of from a company profile perspective, we're certainly looking for businesses which are already commercialized. So from the pre-revenue aspect we were just mentioning there, that can be trickier for us to work with. Our lending partners and the insurance partners are very focused on sort of taking the growth risk and the scale up risk, but they do want to see some evidence of good market traction and market demand. And that, it's more a rule of thumb, but that typically comes at around the sort of $15 million revenue mark, and that's sort of good quality revenue, either repeatable or sort of fully ramped, as opposed to pilot or testing type revenues. There's not necessarily need to be profitable. A lot of the companies that we work with are still, call it 12 to 18 months from break even. But there is a clear sort of need to be able to identify the toggles a company can pull to achieve break even, and certainly there is a sort of a requirement for this to be seen as the last cash in the door before break even. So these companies are not reliant on another capital raise to fully fund the business plan. From an IP perspective, it is a really interesting question, because the insurers and lenders that we work with are able to sort of identify and look at sort of a very broad range of sort of intangible assets, and that will range from sort of the registered rights, the trade secrets, all the way through to sort of who's on your cap table, any agreements you may have with key partners. What they're really looking for is a strong technological or competitive moat provided to a company by their intellectual property assets. So that is going to be a key part of the diligence that both the lenders and the insurers look for. And look, finally, I think this is slightly more variable, but clearly strong equity sponsors are very helpful as well.
Yeah, so presumably the lenders are looking at sort of who's backing the company effectively.
Exactly, yeah.
That makes sense. So effectively then company can leverage its IP to effectively secure cash in the door, last layer of funding, as you say. What are the typical sort of structure and terms and things that people get if they take that route?
Sure, and I guess it is really depends on the underlying sort of situation. The focus of this solution is to be as flexible as possible, because there are no two situations which are created equal. The loan sizes that we typically work with will range from $15-20 million sort of up to 75 million, and it's sort of depending on need and serviceability. These structures are designed to be completely flexible, so that's sort of single tranche to multi-tranche structures. We've worked on a number of revolving credit facilities, which is quite unique in the growth space. But again, it's really sort of comes down to the underlying need of the company. We're typically targeting a mid-teens cost of capital here, and I say that's more focused on the sort of the pre-EBITDA companies. Clearly, the target would be slightly lower if we were working with sort of cash flow generating companies. From a security perspective, this is an important sort of point to make as well. The lenders are looking to take security on sort of all assets of the company, including IP assets, as you would typically expect in a standard senior secured financing transaction. But they're not looking to sort of take the IP out of the company and hold on to that themselves. There are some warrants attached to these facilities. Some of the lenders take a small portion of warrants. Some of the lenders take no warrants at all. I think one of the distinguishing features of I guess this type of debt over more traditional venture debt is just there's going to be a lot less sort of equity dilution in the form of warrants.
Perfect, thank you. And in a life sciences business, because IP is so important, it's a fundamental asset to protect, particularly once it comes to the point where it could go somewhere. So Rebecca, perfect opportunity to bring you in here, I think, as well, just to talk about how IP insurance might be able to help with that kind of comfort that businesses can get that their IP is truly protected.
Yes, absolutely, Carol. So from an IP insurance perspective, it can help in a commercialization phase in a number of ways. I think the first point I will make is around the cash flow, is there to protect companies' cash flow as well. So coverages like IP infringement defense are already there designed to cover the legal costs and expenses of a company looking to defend a claim that's been made against them, for example, because one of their product services has infringed on a third party's IP right, such as a patent or even a trademark. The insurance is also designed to cover damages or settlements that result from it. So essentially, it helps the company's capital and cash flow because the capital is not being tied up in resolving a dispute, and then it can be used to essentially grow the company and grow the business. I think a second point here is around the protection of the value in IP itself and the protection in the investment that companies have made. So a lot of times, especially in the life sciences space, they're going to be very R&D heavy, especially with a lot of IP-rich, products and services being created. I think the last thing that these companies would want is, of course, one of their patents or even a trademark being validated or have their title ownership taken away for whatever reason. So this is actually called an coverage called IP rights protection, and it's designed to cover the cost of defending the IP assets and the ownership and title to the IP. I think a final point I will make is around the balance sheet protection piece as well. So this is where, for example, companies are licensing out a patent to third-party licensees. And what they are doing is offering an IP indemnity in one of those licensing contracts. If the indemnity itself is relatively high or even uncapped, that is currently sitting on their balance sheet. And this is probably a good time to consider their risk management procedures and whether actually it will be better for the company to be transferring that IP indemnity off of their balance sheet into the insurance market, thereby protecting the balance sheet from these IP indemnities that they might be offering out.
Interesting, because the balance sheet is so important, isn't it, for funding and suppliers, customers, etc. So that's really interesting. And just in terms of the sort of idea of insuring in this way, what territories could you cover with this?
Sure. So the IP insurance policy can be quite flexible. So it can be designed to cover all like globally, worldwide jurisdictions. So this would include the US, for example, which can sometimes be more litigious than EMEA. But also some companies can also choose to only cover certain jurisdictions where they have products and services or where they are launching existing products and services, but in a newer jurisdiction. So it's designed to be quite flexible there.
And are there any exclusions that companies should be aware of in terms of what they can actually protect?
Yeah, so there's each policy wording will have a different set of exclusions and conditions that are sort of tailored to the insurers there. I think a few exclusions that I would probably highlight as sort of existing in the majority of the policies are around, for example, a deliberate act of infringement. But this will be by final adjudication of a court. So yeah, it wouldn't be from the offset, but if the final court essentially says that there has been deliberate acts of infringement, then that could potentially preclude the insurance coverage there. Other things include known circumstances or pre-existing matters that have already been made aware to the insured prior to them getting the insurance policy. Those types of instances would also potentially preclude coverage. And then a third and probably final point I will make is around retaliatory proceedings. So this is where, for example, an insured goes after a third party without having IP enforcement cover, for example, and then is sued in retaliation by that company. In some instances, this could also be a scenario that precludes the insurance sort of coming in.
Perfect, thank you. So it sounds like there are lots of things you can do to protect your IP and also opportunities to leverage it, which is great. Ross, I'm just going to come back to you. So we're well and truly into commercialization, I think now, and that sort of phase. So businesses are going to be potentially starting to make profits. There's going to be possibly even some tax payable, which is a nice problem to have. So I just wanted to sort of throw the question to you: what sort of things should businesses be actually thinking about when they are well and truly into the commercialization phase beyond the stuff that we've already covered?
Yeah. So, I mean, I think the first point is an obvious one, which is as you become profitable, you need to pay tax, and that makes you much more interesting to tax authorities. And so the nature of your interactions with tax authorities and how you think about tax within your organization probably needs to change at that point. We've already spoken about sort of patent box and similar incentive regimes in other markets. The really key thing is you need to plan for that before you're profitable, but they'll sort of become beneficial at such point in time when you get profitable. What we see tending to be the real challenges for companies once they're profitable is this tension between the business, quite understandably, just wants to get on and grow and make money, but the tax rules often come and provide counter pressure against that. So it might make inherent business sense just to hire someone who's the right person for the job without thinking too much about their geographical location. But unfortunately, tax does have the concept of sort of geographical boundaries. So the act of hiring someone out of market can expose you to new taxes in terms of employment taxes. It can change outcomes in terms of transfer pricing and just ultimately bake possibly cost, but also risk into your structure. So it's about finding that balance of the commercial sort of requirements of the business with the tax reality as the business really grows. Because ultimately, tax is really focused on people, and tax applies where people are located and where they're driving value from. So if you've got a very dispersed model, you can end up with tax exposure in a lot of different jurisdictions, which can be challenging to manage. And if you don't pick up on it in time, then it can also become very costly to resolve. And I think the other part from a tax perspective that's often quite challenging is that even if you identify those tax matters early on, you can very quickly see businesses sort of shifting focus. So maybe the US market gets opened up and all of a sudden CEO and C-suite and other senior individuals start to accrete in the US. That can have a fundamental impact on the design of your overall tax strategy, both in terms of potential risk of exit from the UK with an immediate charge to tax, but also risk of controversy with the UK and the US basically haggling over who gets the right to tax those profits. So yeah, that's where tax unfortunately sort of interacts in a potentially negative way with a business just trying to grow and do the right thing. And yeah, you just have to be aware of those points as you're going through that process.
Yeah, and it's one of those things. The businesses nowadays that are even earlier stage are increasingly international, aren't they? So it's a case of really understanding where you need to take the talent and managing that through the journey, so that there are no surprises. And it takes us quite nicely onto almost that sort of maturity exit, whichever comes first, phase for a business. And thinking really about what sort of issues come up typically on a due diligence, because if a business is going to exit, they're either going to list or sell, might be PE-backed, might be trade, but there's going to be some sort of transaction. So Ross, just staying with you briefly, presumably a lot of the things you've just touched on are actually issues you see on a due diligence, but are there any other thoughts that you've got around that you've seen in your experience?
Yeah, I mean, it's definitely those issues. So R&D is a big one in the sector, particularly with the growing complexity around the UK R&D regime, but also similar R&D regimes around the world, and changes in those regimes. Companies need to be really on top of that. Employment taxes is another big one where you've got contracted labor. HMRC and other tax authorities are increasingly hot on, well, it might say on paper they're a contractor, but are they actually a contractor? Should you be withholding employment taxes? And that really matters in terms of the quantum, because like if we look at the UK regime, it could be an up to 45% withholding obligation just on the tax side alone, plus national insurance on top. And that's an obligation of the company, and HMRC would come after the company for that. So it becomes a very significant sum very quickly if those risks aren't managed. Depends on the type of business, but sales taxes and VAT can be a very significant issue as well. particularly where you're going international, selling into new markets, there's a different tax threshold often from an indirect tax perspective than there is from a direct tax perspective, and you may have exposure to those taxes even without actually having boots on the ground in that territory. And again, that can become a very big number very quickly because it's a tax on the gross revenue. It's not a tax on profit. So I think those are some of the areas. And then transfer pricing as well is always a hot topic where people like me will be really interested to understand who does what around the organization and where do they do it from, and then trying to work out, well, is there risk that maybe one of the territories has been under rewarded in light of where the functions sit?
It's always comes up on a diligence, doesn't it? There are always questions. Samantha, same question to you, just in terms of where do companies typically trip up, I suppose, on their accounting?
Yeah, sure. I guess one of the big questions is actually one that Ross alluded to at the start, which is, where does the IP sit? If you're looking at commercial exit, does it actually sit inside the company or inside the group? You can have circumstances where the IP has historically sat in one part of the group, and over time new companies have been added to do certain things with that IP, but the IP is actually somewhere separate. In which case you may have some restructuring to do as a result. So that's probably the biggest question. Where does the IP actually sit? And that just totally reinforces Ross's message about prepare early, really. The second question is, is that IP really commercially viable? And then what period what period is it commercially viable for? And I think companies can actually really help themselves here by spending a lot of time thinking about a bit of accounting that often people just sort of gloss over, which is revenue recognition policies. So, long gone are the days where we said, turnover is sale of goods or services exclusive of sales tax. Well, we know that you sold something, that's the definition of income. And the regulators are really pushing companies now to be very explicit about what are the revenue recognition policies in relation to, in this example, intellectual property or R&D. What have you got? Have you got outright sales? Many companies will easily come up with 5 or 6 different revenue recognition policies when they really sit down to think about it and split it all out. Have you got collaboration revenue where you've sold certain rights but retained ownership of part of the IP, and therefore you're getting, you might be getting upfront payments, you might be getting milestone payments, you might be getting royalty payments or license fees or what have you, and really being able to split out those things some years ahead in the accounts and actually show, this is a professional, mature business that's really thought about its actual core operations and can demonstrate it on paper. Reading the revenue recognition accounting policies, I'm not joking, a good set of policies brings the business to life, and investors and readers of the accounts can go, I understand what that business does. I've got it. That's much more something I'm interested in, and it's really helpful for people to spend some time on that often underlooked, underviewed, undervalued area of the accounts. So definitely recommend having a look at that.
Really, really, really good tips there. So thinking a bit more widely, Sam, Rebecca, what sort of things do you see from an IP perspective when there is some sort of transaction?
Yeah, sure. Happy to take this, Carol. So I think from an IP risk perspective, there are some things to know, I guess, with M&A transactions in general, as well as trade sales or even IPOs. And M&A or IPO is arguably a time when a company has increased exposure to IP infringement risks, purely because they are, I guess, more on a competitor's radar as a growing competitor themselves, or because they could potentially be viewed as more vulnerable during these times when management is sort of being pulled in all directions. And both of these scenarios could potentially lead to increased IP infringement exposure. So it's definitely prudent to consider your IP risks at this time, especially when undergoing like an insurance due diligence. And then I think on the other hand as well, it's also prudent for companies to be considering making sure that all of their insurances are in a row, prior to an M&A in order to ensure that they are in good shape, and also to potentially help them attract the right buyers as well for a trade sale or an M&A transaction.
And Sam, what happens if you have some IP-backed lending at this sort of point? What sort of things do you see there?
Yeah, sure. And I think look at what we would typically expect to happen as and when is you sort of go through one of these procedures, depending on whether it's an IPO or a trade sale. Is the debt can of course stay on the balance sheet, but also more likely it will probably be refinanced out, whether that's through sort of a repayment or an additional cheaper facility coming in as those companies reach a certain level of maturity, whereby they're able to access sort of more advantageous terms in the debt markets.
No, that's helpful. Right, I'm very conscious of time, so I think we draw the discussion to a close there and give the audience a few minutes for questions. I've not spotted anything in the chat yet, so I'm going to continue with Sam. I think just ask you a question while people put their thinking caps on. An audience, please do put your questions in that box, and we will definitely answer them. So Sam, how do you almost prove the value of your IP in a sort of IP-backed financing situation?
Sure. Yeah. Look, I mean, there are a range of different methods for sort of a valuation of intellectual property assets, and sort of I won't go into them now because there are probably a lot better educated people to speak in those than I. But essentially, the way it typically works for the processes that we work on is you would engage, or the lender and insurers would engage a third-party valuation provider at some stage in the transaction to assess the intellectual property assets. This assessment can take the form of a sort of a conventional valuation, or it can take the form of sort of a more qualitative commercial assessment of the IP. But all of it is with the aim to sort of getting to that understanding of the competitive moat afforded to a company by its intellectual property assets. I must say that one of the things which we do is this type of engagement with a third party obviously comes with a cost. So it typically isn't done until after there is a signed and agreed term sheet between the company and the lender, aka greater certainty that a financing is able to proceed.
Perfect. We've got a couple of questions in, both for you, Rebecca. So first one is, are you able to talk to life sciences issues specifically arising from W&I policies in an M&A transaction?
Sure, Carol. So to be fair, the brief answer is I'm probably not the best person. We do have a specific W&I team within Aon that has focused on life sciences as well as the industry specifically. So we'll be more than happy to essentially connect you with some of the colleagues there. With that said, I understand that there has also been talks about IP-specific issues and essentially what W&I insurers might not be able to cover in respect to IP, and how actually having IP-specific insurers that look at W&I from an IP perspective has essentially been possible over the years. So we'd be more than happy to share more with you on that offline. In terms of the second question,
yes. Second question, just to read that out for people. Where can we get more information on IP insurance, what it covers, what it doesn't cover, and what it costs?
Sure, yeah. So we'll be more than happy to share more information alongside the slides that we'll be sharing with you. Aon also has an intellectual property website that has information on what the coverages are. So yeah, we'll be more than happy to share those types of information with you. If there is a specific risks that you are looking to insure, you can also talk to us as well, and we will be able to essentially have a conversation with you, understand the exposure in a bit more detail, and actually maybe procure some quotes for you as well and some terms, so you can see what a pricing could look like for your company and your business, including the type of deductible structures and co-insurance structures that are suited for you. So we'll be more than happy to have, conversation as well after this.
Perfect, thank you. We've got another question in. What are the different methods of valuation of IP from a research early stage startup perspective? Also, how different IPs are accumulated over time, either internally developed or licenses valued in terms of future economic value. So is there some sort of framework? So I think it's kind of a valuation of IP question and how that works. Ross, shall I pass that to you initially? I realise you're not a valuations specialist, but you will have seen a chunk of this stuff. So
Yeah, so I mean, yeah, as Carol says, I'm certainly not a valuation specialist, but I can talk to what I've seen in practice. And really the two most common methods I see are sort of a cost-based valuation method for sort of really early stage unproven IP, which is maybe still sort of subject to regulatory approvals or whatever it may be. So it's effectively how far down the line have you got with the process that someone might be willing to pay you effectively to reimburse you for your cost because they can pick up at a later stage. So sometimes see that in the really early stage activities, and probably the most prevalent valuation method for IP generally is a discount for future forecast cash flow approach, where you essentially have to look at what are the expected future cash flows that could be derived from the IP, and then you discount those back to present day value. To get more technical than that, we definitely need a valuation expert on the call, but hopefully that gives at least an idea.
For us. And Samantha, just very quickly, from an accounting perspective, valuation, I guess, means something slightly different, just in terms of what, because you wouldn't necessarily upward value something, for example.
No, that's right. The financial reporting standards are pretty clear that it's the cost or value that can be reliably measured. So cost obviously is, is a fixed expense and can't be uplifted. And the value would take place really, I guess, on a commercial transaction where, you have decided that you're willing to pay this value for this asset. It's probably worth saying that, it's again, you need to look at the definitions of internally generated things, because internally generated brands, logos, customer lists, publishing titles, et cetera, people quite often think, oh, I've got IP. You haven't got IP under the standard. I'm afraid that's expensible items. So yeah, but I think Rebecca wants to come in on this one as well, actually. I see.
No, I think I'm conscious of time, actually. I think we should probably draw a line.
Okay.
But if anybody does have any questions on reflecting on today, please do get in touch. My contact details are on the screen. So in terms of key takeaway, I think it's think holistically, think early. That was kind of the key message, I think, coming through to me, and definitely have an IP strategy, be proactive. So I hope you found today helpful. Thank you to the panelists. Thank you to everyone for joining as well, and hope to see you all again soon.